Sorry?
I cannot clear.
What?
This may be taken up next. In the Thursday, I have filed out.
Prayer rejected.
Serial number
Super mention करके ना कोई adjournment मत मांगो. All the prayers of mentioning stands rejected.
Because I have some problem.
You have been having problem in all the cases. आप कोई भी case जो है ना 4 बार adjournment हुए बिना करते नहीं हैं. आपके choice से हम लोग नहीं चलते.
Serial number 12 may be taken up in
12 में क्या है?
सेकेंड अपील है अंडर ऑर्डर 41 रूल 11 में. उसमें IAB फाइल के स्टे के लिए
क्या मैटर है?
मतलब नीचे दोनों कोर्ट में योर लॉर्डशिप उसका प्लेंटिफ का सूट डिसमिस्ड है. दैट इज अ कंकरेंट फाइंडिंग मिलॉर्ड अफर्मिंग द ऑर्डर ऑफ द ट्रायल कोर्ट मिलॉर्ड. But Milord, in the appeal, Milord, the judgment has been modified, Milord.
Modified saying what?
Saying
what?
Modifying by giving your lordship the occupational right to the plaintiffs, your lordships, affirming the judgment, but modifying the judgment, giving occupational right to the plaintiffs, your lordship, and we, by which your lordship, we the defendants are agreed, Milord. We are the defendants.
Any execution case filed?
Yes, your lordship.
What is the stage of execution?
एग्जीक्यूशन के लिए चल रहा है वो
क्या चल रहा है?
एग्जीक्यूशन में वो अमीन का रिपोर्ट वो
defendants have been found to be in possession of the property.
Yes, we are in possession, your lord.
If you are in possession, you be happy about it.
But Milord, the plaintiffs का ये हो रहा है, plaintiffs का एग्जीक्यूशन केस.
आपको eviction का ऑर्डर है?
हमारा I am the one, your lordship.
आपको अगर आपके being a plaintiff, is there any order of eviction against you?
The moment, your lordship, they will get occupational right, we will automatically get evicted.
ऐसा नहीं है. ऐसा नहीं होता है. प्लेंटिफ के केस में प्लेंटिफ का इविक्शन ऑर्डर हम नहीं देखते हैं.
नहीं, हम प्लेंटिफ नहीं हैं.
जो भी आपका ये कहना है ना.
हम डिफेंडेंट हैं. आई एम इन द पोजीशन. प्लेंटिफ का सूट डिसमिस हो गया हुजूर, एंड वो ऑर्डर अपील में अफर्म भी हुआ, बट इनडायरेक्टली मिलॉट द ऑक्यूपेशनल राइट हैज बीन ग्रांटेड टू द प्लेंटिफ्स, योर लॉर्डशिप.
And you have been directed to be evicted. Is there any order of eviction?
No, there is no eviction, but we are in position जहाँ पे हम पोजीशन में हुजूर, अगर वो ऑक्यूपेशन में आ जाएंगे तो we are likely to get evicted, Lord. क्योंकि जहाँ पे
wait for your turn, there are lot many matters fixed. I cannot tell you. जब आपका केस पिछली बार टेकअप हुआ था तो आप ही एब्सेंट हुए.
नहीं हुजूर, टेकअप नहीं हुआ था. हम थे हुजूर, हम टेकअप नहीं हुआ. नहीं तो हम नहीं करते. हम मेंशन करके इसको लगाए हैं. और पिछला 5 या 6 बार 6 वीक से घूर रहा था हुजूर, आ रहा है लिस्ट में, लेकिन टेकअप नहीं हुआ. टेकअप नहीं हुआ.
वेट करिए.
और एक प्रेयर मिनट, अगर ये नहीं होता देन आई मे बी गिवन अ लिबर्टी टू मेंशन एट 4:30 सो दैट इट कैन बी टेकन अप बाय टुमारो.
आप वेट करिए ना अपने टर्न का. हाउ डू यू अज्यूम कि क्या होने वाला है? ऐसा नहीं हो कि जब केस कॉल आउट हो तब आप एब्सेंट हो. बस इसका ध्यान रख लीजिए.
आई विल ट्राई नॉट बिकॉज़ देयर आर
आई डू नॉट नो. जब केस कॉल आउट हो तब एब्सेंट मत रहिए.
आई विल ट्राई नॉट.
जब 5 मिनट आप मेंशनिंग में लगाए हैं तो थोड़ा सा अटेंटिव भी रहिएगा.
आई एम अटेंटिव, बट देयर आर अदर माय लॉर्ड मे अप्रिशिएट.
From Secretary list for final to item 1, first appeal 176 of 118.
I have engaged senior on behalf of respondent.
In which case?
8 number case, second appeal.
तो क्या करें हम?
Pass over for the day.
Rejected. हाईकोर्ट वाला जजमेंट है वो कौन सा वाला उससे रिलेटेड था? जगह का नाम
विलेज
बताइए।
पोचरा,
हाँ?
विलेज पोचरा।
विलेज। कल आप लोग का सारा सबमिशन लिखा दिए। After hearing the learned counsels appearing on behalf of the parties, this court finds that there is no dispute raised by the appellant in connection with compensation regarding any construction, etc. The sole point for determination in the present case is as to whether the learned court, learned trial court, is justified in fixing the fair market price of the property involved in this case, in these batch of cases, all falling in village Kadru at the rate of ₹3,000 per decimal. इसके अलावा तो कुछ नहीं है।
And other benefits,
Sorry?
solidity of interest भी दिया गया।
वो तो दिया ही गया ना, वो तो दिया ही गया, उसमें तो कोई डिस्प्यूट ही नहीं है। अगर यहाँ पे रेट एनहांस होता है तो अकॉर्डिंगली वो फॉलो करेगा और द डिक्री विल बी ड्रॉन अकॉर्डिंगली, करेक्ट? The dates पे ध्यान देंगे, है ना? It is not in dispute that large chunk of land was acquired under Land Acquisition Act 1854 and the notification under section 4 is number 363/RA dated 3/4/2003. Which was followed by quantification of compensation by the concerned authorities and the land users had received compensation under protest on 11/1/2007. सबका सेम डेट है?
सबका सर।
On 11/1/2007. ये सारा कुछ इम्प्यूट ऑर्डर में ही मिलेगा। The case was referred to the Collector Ramgarh under Section 18 of Land Acquisition Act at the instance of the claimant. The land bearing in various plots, the details of the land bearing in various plots has been given in paragraph 2 of the impugned judgment, which is not in dispute. And these batch of cases are from village Kadru, within Patratu police station under the then district of Hazaribagh and now falling under district of Ramgarh, which were acquired.
पुलिस स्टेशन पतला अंचल भी पतला
ऐसा तो हमको इंक्लूड ऑर्डर से नहीं दिख रहा. Falling under Ramgarh, which was acquired for construction of railway line. The records reveal that the claimants claimed compensation at the rate of rupees 15,000 per acre. And examined two witnesses, PW1 Bandhan Media and PW2 Real Media, and produced the following exhibits. Exhibit list मिलेगा page number 8.
that is page number 8
The opposite parties examine only one witness, namely Manoj Kumar, as OP witness number 1. And further, no documentary evidence as such was produced from the side of the opposite party. The specific case of the claimants seeking enhancement of compensation was that the market value fixed by the collector in connection with the acquired land was not in accordance with the prevailing market rate at the time of notification under Section 4 of the Land Acquisition Act. And the acquired land have changed the nature and was fit for construction of building, and the market rate was not less than rupees 15 lakhs per acre. The classification in connection with the land was also challenged, and it was asserted that the acquired land was within Ramgarh Cant and was surrounded with all facilities available in connection with road, electricity, water and good commercial connectivity. It was also asserted that similar land which were acquired way back in 1986 for defence activities, the court had fixed rupees 2.5 lakhs per acre, which was confirmed by the High Court in appeal. And an attempt was made to calculate. It was also asserted that, as per the law laid down by the Honorable Supreme Court, from the year 1986 to the date of notification under Section 4 of Land Acquisition Act, 10% per year should have been granted as appreciation in the value of land. However, from the exhibit list, it is apparent that no award of the year in connection with acquisition of the year 1986 was exhibited. उस समय का कोई award का exhibit नहीं, was exhibited by the claimants. During the course of arguments, the records reveal that so far as Exhibit 4 is concerned, the same was in relation to village Bujur Jamira. Bujur Jamira. And the award was passed on 29/2/2016, wherein the court had recorded that the valuation of the land should be fixed not according to agricultural classification, considering the fact that there was effective commercial, social and communication development in and around the vicinity of the acquired land in the district of Ramgarh. ये भी इसी से related था, railways. The land so acquired, which was subject matter of consideration in Exhibit 4, was also regarding acquisition for railways. And जो चीज़ नहीं पता हो ना तो बता दीजिएगा नहीं पता है, ऑर्डर में गलत हो जाएगा तो बहुत एरर हो जाएगा. And compensation was fixed at the rate of rupees 3,000. Exhibit 4.
8,000. That has been mentioned in paragraph 13 of that. Page 13.
Just
Page 13, second line.
compensation was fixed at the rate of rupees 8,000 per decimal. So far as the land is concerned. However, by Exhibit 4 by A, which was in relation to village Dagi Dag, the compensation was fixed at the rate of rupees 6,000 per decimal, and by the Exhibit 4 by B, the
Village Teliatu.
which was in relation to village Teliatu, the compensation was fixed at the rate of rupees 7,000 per decimal. All the compensation were fixed at flat rate with respect to each villages. The Exhibit 5 was the map of Patratu Anchal in district Ramgarh. And The villages, namely Bujur Jamira, Tilayatu, Teliatu, Dadidar, Podi, and Kadru, were found adjacent to each other, are shown adjacent to each other, correct? इसमें
Correct.
कोई error नहीं होना
No.
चाहिए. ठीक है?
Either they are touching the boundary, northern side, eastern side, all are adjacent.
Are shown as adjacent to each other. It further appears that the learned trial court, while considering the various exhibits, has in particular referred to Exhibit 4, whereby the compensation was fixed at the rate of Rs 8,000 per decimal, which was for the adjoining village, namely Ujur Jamira. This court also finds from the improved judgment that the learned trial court in paragraph 12 has recorded that on account of effective economic, social and communication development, importance of land under acquisition had considerably increased, and therefore on the basis of evidence on record, the learned trial court found that Ramgarh town is situated adjacent to land in question, and accordingly its valuation should be fixed by the court, not according to the agricultural classification which was wrongly done by the collector under that. This court finds that the finding which has been recorded in paragraph 12 has not been challenged by the respondent by filing any cross appeal or cross objection. And this court also finds that under similar awards passed in connection with adjoining villages, in connection with which नहीं इतना काफी. This court further finds that the appellant has filed this appeal by taking valuation of the appeal at Rs 8,000 per decimal, and the specific prayer has been made by the appellant in the first appeal that the compensation of the land should be enhanced to Rs 8,000 per month. And accordingly, the court fees, etc., has also been paid by the appellant. However, the same has apparently been done in view of the fact that the exhibit 4, which has been taken care of the learned trial court, has shown the amount of compensation at the rate of Rs 8,000 per decimal. But while fixing the compensation has been fixed at the rate of Rs 3,000 per month per decimal. However, the appellant has placed on record other orders by way of additional evidence. And ये E/3 कौन से पेज में है? जिसमें 8,800 फिक्स हुआ है?
32. 32 to 53.
फिफ्टी थ्री में तो ये तो 8,000 रुपए है, 8,800 रुपए कैसे लिख दिए हैं? ₹8,000 है भाई। आप अपना
व्हाट्सएप इनर पेज 22 देखा है, इसमें 10% का एप्रिसिएशन दिया गया है, तो 8,800।
10% की वृद्धि देते हुए
भू अर्जन की तिथि है 18/9/2005, करेक्ट? और आपका है भू अर्जन की तिथि पहले का।
1.5 साल के बाद का है।
And through the additional evidence, three orders have been brought on record, has been prayed for consideration. That is annexure A E/1, A E/2, A E/3 and A E/4. the the interlocutory application revealed that the appellants are relying upon the following documents for the purposes of fixing of compensation. ये आगे का पेज 7 में इसको लिस्ट डालूंगी. However, during the course of hearing, the only additional evidence which has been referred to for consideration is Annexure AE4, which is the certified copy of the judgment passed by this court in First Appeal number 145 of 2013 and other analogous cases in connection with village Pochra, wherein the compensation has been fixed at the rate of rupees 20,000 per decimal. The exhibit AE/1 is dated 29th of March 20 March है कि 29th March है AE/1 is dated 29th of March 2024 29th of March 2019, wherein the rate has been fixed at 7,000 per decimal. Which is which has been passed in connection with the village Mohana, correct? And the date of notification under section 4 is 3/4/2003. So far as the exhibit, so far as Annexure AE/2 is concerned, the same has been fixed. The same is in connection with village Sidwara Kala, granting compensation at the rate of rupees 11,000 per decimal. Right. Award dated 28 February 2018. However, the notification in the said case is dated, notification under section 4 in the said case is dated 17/12/2004. So far as the Annexure AE3 is concerned, in the said,
इसमें लॉट से पे 11,000 से आ गया सिद्धवार
हाँ?
सिद्धवार के नाम पे 11,000
किसमें?
नहीं सिद्धवार के नाम
तो हम कुछ और लिखाए हैं क्या?
नहीं केवल रेट नहीं लिखा है
लिखाए हैं ना 11,000. ऐसे बीच में नहीं डिस्टर्ब करिए, ध्यान दीजिए.
सॉरी
So far as exhibit AE3 is concerned, the compensation has been fixed at the rate of 5,800 as 10% increase has been given, and the date of acquisition in the said case is 18/9/2005. And so far as annexure AE4, which has been heavily relied upon by the learned counsel for the appellant during the course of hearing, is concerned, this High Court has enhanced the rate of compensation to be at rupees 20,000 per decimal by referring to the circle rate dated 17/8/2004, and by observing that the circle rate was prepared on 17/8/2004, just 2 months before notification in the said case was published in the official gazette. Meaning thereby the acquisition in the said case was relating to notification under section 4, which was sometimes in the month of October 2004. It further appears that the circle rate was duly exhibited before the learned trial court, but the circle rate was not considered by the learned trial court while fixing the compensation. And this court considered the circle rate to be in proximity with the date of notification, which was just 2 months prior to the date of notification, and enhanced the compensation to rupees 20,000. This court is of the considered view that the judgment passed by this court in first appeal number 145 of 2013 is not at all applicable to the present case, as the notification involved in the present case is dated इस केस में, हमारे केस में in 3/4/2003, which is much prior to the circle date, which was a part of the record in FA number 145 of 2013. And further, in the present proceedings, the circle rate prevalent on the date of notification or in the vicinity in point of time with respect to the date of notification has not been exhibited either at the trial court or even before this court. This court is of the considered view that the circle rate which was exhibited in the aforesaid case FA number 145 of 2013 passed by this court was dated 17/8/2004, and the same cannot be taken into consideration in the present proceedings. and accordingly the argument of the learned counsel for the appellant by seeking enhancement of compensation to the extent of rupees 20,000 per decimil on the basis of the judgment passed by this court in FA number 145 of 2013 is hereby rejected. So far as the other additional evidences placed on record are concerned, the same also do not arise from the same notification. Rather, the higher rate of compensation was in relation to those acquisition in which the notification was much after the notification involved in the present case. Though those documents have not been placed during the course of hearing, but on perusal of those documents, this court finds that no benefit can be given to the claimants on the basis of such documents. However, it is sufficient to observe that in LA case number, in Annexure A/E/1, where nothing is there on record to suggest that village Masmohana was adjoining to the village, इस village का नाम village Kadru involved in the present case. वो तो adjoining नहीं है, मसमोहना तो adjoining नहीं है.
जैसे पंचायत दिस साइड में थोड़ा टच करना है, नॉट एग्जैक्टली
वैसा कोई एविडेंस भी नहीं दिए हैं आप, इतना मैप देख देख के हम लोग क्या ही बोलें.
बट द रेलवे ट्रैक इज पासिंग टू बोथ.
रेलवे ट्रैक यहाँ से दिल्ली तक जाता है, तो यहाँ का रेट और दिल्ली का रेट सेम हो जाएगा. यही चीज तो हम आपसे पूछ रहे थे कल. However, the fact remains that the learned trial court has taken into consideration one of the judgments dated 29 to 2016, which is Exhibit 4, relating to adjoining village, namely Bujur Jamira. Which was also acquired for the laying down of railway track, and has also recorded that the compensation in the same case was fixed at the rate of rupees 8,000 per decimil. But while fixing the rate of compensation, the learned court has fixed the compensation at the rate of rupees 3,000 per decimil. And for this